Hello, everyone. Welcome to today's webinar. I'm John Balitis. I chair the Labor and Employment Department at Jennings Strouss, and I'd like to thank you for joining us today. As many of you know, we host webinars like this, and in non-pandemic times, live seminars, as a way to keep connected with our clients and to provide valuable information to you. And that's what we're going to do today. We're glad that you're with us. I have with me my colleagues, Julia and Dina, and together we're going to cover some very interesting topics for you. We're going to run about an hour, hopefully have a little bit of time at the end for questions, but if you have a question that doesn't get addressed today through the chat, or you think about it after the fact, as always, please reach out to one of us. We're always happy to speak with you after the webinar to address any questions or concerns that you have. Also, if you are an attorney and you are looking for CLE credit for the webinar today, please just let us know in the chat, include your full name and an accurate email address, and we will get you taken care of. And finally, in the housekeeping department, this is being recorded. If you want to watch it over and over again, which some people do, they love these, or if you have other people who you think might be interested but didn't have a chance to join us today, feel free to let them know. Go to the Jennings Strouss website, go to the events page with webinars, and it'll be there for you to watch as many times as you like. Before turning to Julia and Dina, I want to cover just a few updates for you that we think are important. I'm going to go through them really quickly because I want to make sure we have enough time for the main topics today. And I want to start with paid time off for employees relating to pandemic conditions. As you may recall, around this time last year, Congress passed the Families First Coronavirus Response Act, which included in it new paid leave entitlements for workers. So if a worker could meet certain criteria that was related to the pandemic, they were entitled to take additional paid FMLA time off. They were entitled to take emergency paid sick time off. And you had a mechanism whereby you could get reimbursed for the amounts you paid to these people for the time they took off for these reasons. These leave entitlements technically expired at the end of 2020. They are no longer entitlements. But as many of you may know, in 2021, they became options for you as employers, meaning you could continue to offer this type of leave, paid leave to workers if you wanted to, and you could still get reimbursed for it. That was the case when we rolled over from 20 to 21. That has now been extended further through Biden's last stimulus package, and it now includes additional criteria. For example, if a worker wants to get vaccinated or has side effects from a vaccination, you can provide that time off to that worker and then get reimbursed for that time, for the money that you pay the worker for the paid time off through the end of September of this year. Very important to know if you want to do it. Once again, it's optional on your part now. It's not required. Additionally, as was the case under the original leave entitlements with the FFCRA, there are daily and cumulative caps for workers in terms of how much money you will receive as a reimbursement. And that's easy to find online, or you can ask one of us and we'll provide that information to you. But what you need to know is that this is an option for you now. You don't have to do it. If you do, you'll still be reimbursed. End of September. That's the important end date for you to remember. Second update I'd like to chat with you about is protection from COVID-related liability. As many of you know, if a worker takes the position that he or she has contracted the virus in the workplace, that most likely will be a workers' compensation issue. That will be treated as though it's an industrial injury. So workers are already dealt with, so to speak, in this area through workers' compensation. But what if you have a customer or a client or a vendor come into your place of business and then contract the virus and take the position that they contracted it at your business site and then want to hold you responsible for it? Well, as you may have heard, there has been discussions in Congress about creating protections for businesses in this area for literally a year, but nothing ever came of it. Nothing ever got done with it at the federal level. So many states have taken it upon themselves to enact local legislation to create this type of protection, and Arizona is one of the states that has done this. Governor Ducey signed a bill last month which provides protection to you as businesses for this type of liability, meaning third parties coming into your business site who take the position that they caught the virus at your business site. Now, but it's important to understand how this law works, okay? To put it in context, if you go to a store and you slip on something on the floor, like a liquid, and you hurt yourself, and then you want to pursue a claim against that store for your injury, what you would do is you would present evidence in a lawsuit, and you'd have to convince whoever's, whether it's a judge or a jury, that the store owner was negligent, meaning he or she acted unreasonably, didn't do or not do something that a reasonable person would do to protect you from slipping in the store, okay? Under our new law, those two standards, evidence and liability, are heightened. They get changed. So if someone wants to try and argue that they contracted COVID in your workplace, they have to prove that by clear and convincing evidence, and then they also have to show that you were grossly negligent as a business owner, which means not just that you weren't reasonable in terms of what you did or didn't do for precautions, but you were almost reckless in what you did or didn't do. What manipulating these two standards does is it theoretically weeds out frivolous lawsuits. Because what it does is it makes it harder for a COVID claimant to prove and succeed on a claim against you. They have to put on a heightened level of evidence. They have to show that you were grossly negligent, not just negligent. What's important to understand about this is it does not provide immunity to you for these types of claims. A lot of people hear about this law that gets passed and they think, oh, I'm all right. I don't need to worry about anything anymore. That's not so. It just makes it harder for someone to prosecute a claim against you, but it does not provide immunity for you. Just keep that in mind. The other important thing about this development is that the law Ducey signed is retroactively effective to March of 2020, all the way back to when the pandemic really started to gain traction here in Arizona and elsewhere. So if somebody has a claim that they've been waiting to bring against you for a perception that they contracted the virus at your business last year, they now are subject to these heightened standards. It has retroactive application. Very important for you to keep in mind. Last update from me is about vaccination mandates. You may recall the last webinar that we hosted, we talked a lot about vaccination mandates and the fact that as an employer, you are permitted to impose a vaccination mandate on your workforce with certain exceptions relating to things like religion, disability, and so on. What you need to know is that there is a bill pending in the Arizona legislature right now. It's in the Senate Commerce Committee that would prohibit you as an employer from imposing a vaccination mandate. If this bill gets passed and signed, it's going to change the game for you if you are an employer that wants to require your workforce to be vaccinated. You need to keep an eye on the bill. If it gets passed and signed, we will alert you to it, okay? But you should keep an eye in the media about it as well yourself. You also should know that there are lawsuits popping up around the country. There's one in California. There's one now in New Mexico. There is not one here in Arizona, as far as we know, involving people filing claims and claiming that they are not required to be vaccinated because the FDA has only approved these vaccinations on an emergency basis. Apparently, there's some obscure regulation in FDA regulations that draws this distinction and actually says that or suggests, I guess I should say, that people can only be required to take something like this if it is approved for permanent use, not for experimental or temporary use. So we will keep our eye on those lawsuits to see if we see one emerge here in Arizona. But you should be aware that these developments are occurring about vaccinations. They are caveats or qualifications to all of the discussion we had at our last webinar because they are new developments. So having talked about that, let's talk about I-9 practices. You know, a lot of you have workers who you have sent home to work remotely and who are still there, but it's not like you all haven't continued to hire people during the course of the pandemic. A lot of people have been hired, but they've been hired with the understanding that they're either going to work remotely or they're either going to work remotely now or for a period of time, whether it's permanent or not. So if you are hiring people remotely, so they're not even coming into your office, maybe you're hiring them and they're starting out as your worker at home, what, if anything, should you be thinking about from a best practice standpoint relating to I-9s? Julia, by the way, is our I-9 expert. So if you ever have a question about this, be sure and reach out to her. Julia, what can you share with our participants today about best practices for I-9s and remote workers?
Thank you, John. And I will do my best, to keep this relatively short. But for those of you that have seen more than one of our webinars, you will know that I personally find I-9s riveting. I could talk for days about I-9s, but first I want to start by backing up to an issue that actually did come up in another webinar. And this is a common misconception, and that is there are apparently some payroll companies out there, some fairly large payroll companies that will do a lot of your onboarding process for you, which is fine, convenient, but a lot of them are accepting individuals' IDs for the I-9, for purposes of I-9, by email or fax, that sort of thing. That in the ordinary sense and on a normal year is not acceptable. You are supposed, whoever it is that fills out section 2 of that form I-9 is supposed to be physically looking at that ID so that they can tell whether or not it appears legitimate or real. That's really the purpose of that person signing, is to say, I looked at this, it's, you know, it has 2 sides or whatever it is. It doesn't look, you know, like somebody drew on it. So you really are supposed to be doing that physically in person. However, right now, because we have so many people working remotely and we want to encourage that to the extent that it's necessary, ICE has actually waived this requirement. You do still have to complete the I-9 timely. So that means no matter what, your new employee needs to fill out section 1, their section of the I-9, on day 1 of their employment. That's always the case. And then it's okay for them to go ahead and send you that by email. But as for the documents, you are allowed to get them virtually right now. So you still only have 3 days, but they can give them to you by email or fax, whatever is necessary, as long as you get a relatively clear image. So that is okay right now if that person is working remotely. If, let's say, you have some people working remotely, but this particular individual is in an essential function and they're going to be in the office, then you must, if this is an in-office employee, you must physically look at the ID just like any other day. But let's say you have this remote employee, you hire them in another state or something like that. They fill out section 1, you get an email of their document, and then this person is ready to come into the office now. Well, in that case, you now have 3 days to go ahead and do that physical examination of the documents. And although they have not specified this, I would recommend that you just provide the list of documents that employees are able to use, rather than saying, oh, please bring me your driver's license, or please bring me your passport, the document that they used previously, because technically that is over documentation. You're not ever supposed to tell an employee what document to provide. So I would recommend just saying, okay, you need to bring documentation from this list in person again within 3 days, and whatever it is that they're able to provide to you, that is what you will use. You then are supposed to write in the comments section of the Form I-9 when you physically examine the document. Now, one thing a lot of people don't realize, if you're fortunate enough never to have been audited, is that ICE is okay with very ugly Form I-9s. A lot of us want it to be all nice and neat and clean. ICE does not. If you have anything to say about a Form I-9, write it on the Form I-9 or write a little memo to file and put it with the I-9 in your files. Because what ICE is going to do, like, let's say it's just not feasible, or, you know, it happened, you dropped the ball, it took 7 days, something like that. You want to avoid that. But if that happens, write a memo to the file. Whatever you do, don't backdate it. Just be honest. Write a memo to the file, say, this is what we had going on. We did it as soon as we could. We had already run E-Verify, and put it in the file. And more often than not, as long as you are not an egregious violator, that is going to be enough to help you avoid any sort of significant penalty. So if you have any questions, though, feel free, reach out. If you just want to hang out, look at I-9s, I'm up for that too. Thank you.
Thank you, Julia. That was excellent. A couple things there that I didn't know. So that was very valuable information. Appreciate it. Dina, who's a new member of our department, which we're very excited about, is going to chat a little bit about how the pandemic impacts your duties to comply with OSHA and the National Labor Relations Act. You probably all know, you're all familiar with OSHA, the Occupational Safety and Health Act, okay? You're required to provide a safe workplace for your workers and so on. The National Labor Relations Act still is a law, very old federal law, that I find many clients are yet even still unfamiliar with. And that's probably because I think a lot of people think of it as a law that deals primarily with union management relationships, union workforces, and that is true. But there is a provision, there are provisions in the National Labor Relations Act that apply to all employers. And the most important one, I think, for purposes of our discussion today, is the provision that allows workers to engage in what we call protected concerted activity. And all that means is that your workers are permitted to communicate with one another about wages, hours, and working conditions, even if it's highly critical about you, the employer. And you cannot chill that, retaliate based on it, take any adverse action against it, because they have a right under the NLRA to do this, to communicate with one another to better their collective good. So with that having been said about the NLRA, Dina, what should the participants know about how COVID-19 impacts OSHA and NLRA compliance?
Thanks, John. Yeah, so I'm going to start with a general overview of OSHA and how COVID-19 has affected that compliance, and then move on to the NLRA. So under OSHA, the Occupational Safety and Health Act, employers are responsible for providing a safe and healthy workplace for their employees. The general duty clause of OSHA is basically a catch-all provision, which requires that all employers provide a workplace that is free from recognized hazards that are causing or likely to cause death or serious physical harm, which, as we all know, COVID has fallen under that category. OSHA also gives employees important rights to participate in activities that ensure the protection from job hazards, such as filing a complaint with OSHA to have their workplace inspected, receiving information and training about hazards and methods to prevent harm in the workplace, reviewing records of work-related injuries and illnesses that occur in the workplace, participating in OSHA inspections and speaking in private with the inspector, and filing a complaint with OSHA if an employee believes they have been retaliated against by their employer for acting as a whistleblower and requesting an inspection or using any of their other rights under OSHA. OSHA applies to most private sector employees in all 50 states, DC, and other US jurisdictions, either directly through federal OSHA or state-approved OSHA plans. Unless you are certain that you are exempt from the Act, you should assume that the standards will apply to your business. So a current worker or representative may feel the need to file an OSHA complaint and request that OSHA inspect their workplace if they believe there is a serious hazard or that their employer is not following OSHA standards or guidelines. Workers and their representatives who have the right to ask for an inspection anonymously, they have the right to anonymously request an inspection from OSHA without OSHA alerting their employers who requested the inspection. It is a violation of OSHA for an employer to retaliate, transfer, fire, or demote in any way an employee for filing a complaint or taking advantage of other OSHA rights. At the end of an inspection, if an OSHA area director determines that there's been a violation of OSHA standards, the area director could issue a citation and potential fines to that employer. The citation and fines vary based on the severity of the violations. As COVID cases have continued to grow throughout the country, so have employer violations. Since the start of the coronavirus pandemic through the end of 2020, OSHA has issued citations arising from 300 inspections for violations relating to COVID, resulting in proposed penalties to employers totaling a little under $4 million. So it's not any laughing matter. OSHA inspections have resulted in the agency citing employers for violations, including failures to provide PPE and medical evaluations to employees, failure to report an injury, illness, or fatality, failure to properly record an injury or illness with OSHA recording forms, and failure to generally comply with the general duty clause under OSHA. Obviously, enforcement of OSHA standards can vary based on different administrations. So under the Biden administration, we've seen an increased enforcement of OSHA compliance. For example, on January 21st, 2021, by executive order, President Biden directed the Secretary of Labor to launch a national program to focus on OSHA enforcement efforts related to COVID, hazardous conditions that put the largest number of workers at risk, and also on employers that engage in retaliation against employees who complain about unsafe or unhealthy working conditions. In response to President Biden's executive order on protecting worker health and safety, OSHA has launched a national enforcement program, also known as an NEP. NEPs are temporary programs that focus OSHA resources on the most critical issue at hand. This NEP advises that OSHA use targeted inspections, outreach, and compliance assistance to identify and reduce or eliminate COVID exposures in the workplace. This NEP went into effect on March 12, 2021, and will remain into effect for up to 1 year, although OSHA has the ability to remove the NEP if COVID side effects subside. OSHA strongly encourages state plans to adopt this NEP, but does not require identical adoption. Most importantly, the NEP is, under the NEP, OSHA is going to place the highest priority on planned inspections addressing fatalities that were related to COVID-19, and then focus on unplanned inspections which have alleged employee exposure to COVID-19 related hazards. OSHA anticipates that the majority of these inspections will continue to occur in the healthcare field and include retirement facilities and assisted living facilities as well. Targeted non-healthcare industries which have really arisen since the start of pandemic include grocery stores, general warehousing and storage facilities, restaurants, and correctional institutions. There's been a huge uptick in COVID cases and non-compliance with OSHA standards in those industries, which we are now seeing a stark contrast to. Since the start of the pandemic, OSHA has handled most enforcement work remotely without in-person inspections. Under the NEP, more inspections will return to on-site visits. For most of the pandemic months, OSHA has handled thousands of complaints it received through an informal process, which allowed employers to self-investigate allegations relating to COVID and report back their own findings and how they are addressing those concerns. Most of the inquiries of this nature resulted in closure of cases without a formal inspection from OSHA. This change back to in-person inspections is in response to concerns raised regarding the agency's activity during the pandemic and these remote inspections. For example, in 2020, OSHA received 15% more complaints than during the same period in 2019, but performed 50% fewer inspections, both in person and remotely. So OSHA will now be prioritizing cases for on-site inspections where the complaints allege potential worker exposures to COVID or involve workers suspected or confirmed positive for COVID-19 or exhibiting symptoms of exposure. This reaffirms OSHA's adherence to longstanding inspection policies that require on-site in-person presence for most inspections. Modifications to that policy now, such as remote inspections, will only occur under limited circumstances. Importantly, under this NEP, there will be an added focus of ensuring that workers are protected from retaliation. So generally, as we discussed earlier, OSHA prohibits employers from retaliating against their employees for using their rights under the Act. Such rights include filing an OSHA complaint, asking to review medical records, relating to safety concerns, raising safety concerns, and the like. Protection from retaliation, as you all probably know, means that an employer cannot punish a worker by taking adverse action, such as firing that employee, demoting them, reducing their pay or cutting their hours, denying benefits, and that sort of thing. Since the start of the COVID-19 pandemic, we've already seen an uptick in employee complaints alleging that they have been retaliated against for complaining about a lack of safety and other COVID protocols in place. This was happening more often in the beginning of the pandemic when employers were still requiring employees to come into the workplace. Now we are seeing more complaints arise among employers that have allowed for remote working during the pandemic that are now requesting their employees come back into the office. Some of these employees do not yet want to return for one reason or another and are claiming they have been retaliated against for complaining that the workplace is not safe enough to return to. So employers need to make sure they are especially clear about the reasons underlying any action they take against employees right now. This is not the time for an employer to write up an employee for having a bad attitude or for gossiping. All employers, particularly those in high-risk industries, should be prepared for heightened OSHA enforcement activity related to COVID-19 exposure and expect more aggressive OSHA investigations of such claims under this new NEP. Employers can attempt to stay in compliance with OSHA standards by actively encouraging sick employees to stay home, providing information and training on cough and sneeze etiquette, hand hygiene, avoiding sharing personal items with coworkers, providing hygiene products and PPE for use by employees, performing routine environmental cleaning and disinfection of shared communal areas, and clearly communicating with their employees when employees raise workplace safety concerns, and being extra cautious not to punish or retaliate against their employees for raising such concerns. I'm sure most of you or other employers have been utilizing these strategies in the past, but it's important to continue to do so moving forward. COVID-19 safety in the workplace also implicates rights under the National Labor Relations Act, known as the NLRA. So as John was saying, a lot of people might normally associate the NLRA with union work, but that is not the case. And it is very important to know standards regarding protected activity under the NLRA, especially with heightened COVID enforcement. The NLRA protects almost all private sector employees, regardless of whether they are union represented or not. So as with the requirements under OSHA, unless you know for certain that you are exempt, you should assume that the standards of the NLRA apply to your business. The NLRA ensures that employees can self-organize, form or join or assist in a union, collectively bargain for changes in wages and working conditions, and participate in other concerted activity for the purpose of collective bargaining and other mutual aid or protection. Under the NLRA, most workers have the right to act together to address work-related issues in many ways, known as engaging in protected concerted activities. Employees discussing work-related issues beyond pay, such as safety concerns, is considered protected concerted activity. I'm going to be saying this word a lot, so I apologize if I screw it up at any point. So protected concerted activity arises when two or more employees take action for the mutual aid or protection regarding terms and conditions of employment. A single employee may also engage in this protected activity if they are acting on behalf of other employees, if they are bringing group complaints to the employer's attention, or if they are trying to induce or prepare for group action. A single employee acting alone is not considered to be engaging in protected concerted activity. So these protected activities can include talking with one or more coworkers about working conditions, circulating a petition asking for health and safety provisions in the workplace, participating in a concerted refusal to work in unsafe conditions, openly calling for paid sick leave, and joining with coworkers to talk directly with their employer about workplace safety conditions. Other protected concerted activity that we've seen arise revolving around COVID could look like employees requesting to work from home or requesting not to return to work after having been working remotely due to risks surrounding COVID-19 in the workplace, employees garnering support to walk out in protest of critically unsafe working conditions, and even employees discussing or even protesting against a mandatory vaccination policy or a lack thereof. All of this is considered protected activity that employees have the right to engage in without being retaliated against by their employer. It's a fine line for employers to try and separate conduct that's considered concerted activity versus conduct that isn't, for the purpose of ensuring NLRA compliance when addressing COVID concerns. This should always be looked at a case-by-case basis. As with OSHA, employers need to be extra cautious right now that they are clear about the reasons underlying any action they take against employees who raise concerns relating to safety and COVID in the workplace. In establishing COVID-19 protocols in the workplace, an employer can abide by both OSHA and NLRA regulations by implementing protocols that tailor restrictions to achieve health and safety objectives without unnecessarily infringing on traditional rights under NLRA and OSHA. For example, it would be better practice to discourage employees from talking face-to-face or within 6 feet of each other, rather than a blanket prohibition of employees speaking with one another or not communicating in the workplace, even on non-working time. Another example of best practice would be for an employer to discourage sharing objects such as office supplies, tools, and printed materials so coworkers could not inadvertently transmit COVID-19, versus instructing employees not to distribute any written materials or paraphernalia. A final example would be implementing off-duty access restrictions for the workplace, justified by the needs to limit and monitor who is coming in and out of the workplace at one given time, rather than barring off-duty access for some but not all purposes, or requiring, or unless the employer grants specific permission. There are other examples as well, but these are all things to just keep in mind as you make decisions regarding COVID and safety in the workplace, and making sure you're not infringing on any rights afforded to your employees. Similar to the whistleblower protections under OSHA, under the NLRA, an employer cannot lawfully discharge, discipline, or threaten an employee or coercively question an employee about their protected concerted activity. However, an employee may lose their protection by saying or doing something egregiously offensive or knowingly and maliciously false, or by publicly disparaging an employer's products or services without relating it back to a legitimate labor complaint. In general, while the coronavirus pandemic continues to persist, employers need to be extra aware of the safety and well-being of their workplace and employees, and be careful not to punish any employees for action that looks like exercising a right under OSHA or the NLRA.
Dina, that was awesome. I think you did a wonderful job of connecting those two really important laws with the current circumstances. You also did a wonderful job of sort of distilling those laws down, because they are somewhat complex, but that was a great delivery in terms of explanations for both of them and how they are really impacted by COVID. One thing I will tell all you guys who are participating is that to just follow up on one thing Dina was talking about as examples of communication. She talked about face-to-face communication, circulating a petition, so on. 5 or 10 years ago, we saw an explosion of unfair labor practice charges, NLRA, NLRB charges, involving employees who were communicating on social media platforms. And I think employers were sort of surprised by it, even employers who were familiar with their obligations under the NLRA, because they didn't really think about the fact that if someone goes home and starts posting on Facebook, and if some of that worker's friends or the friends on Facebook happen to be coworkers of theirs in the workplace, that the dialogue that develops on a platform like Facebook might qualify as a means of communication that could be protected under the NLRA. And it does. So, and the other thing that's true about it is that although Dina gave you some examples of just sort of how far a worker could go before, when they would lose their protection, if there's profanity involved, if the remarks are really critical of you as the employer, even in those situations, the National Labor Relations Board consistently takes the position that the communication is still protected. So, word to you, just a word of advice. If you end up in one of these situations and you're looking at the communication and you're wondering if the worker has crossed the line or not, before you take any action against that worker, it would be good to check in with us or your regular counsel to explore that, because an ounce of prevention is worth a pound of cure. A little bit of advice up front on something like that may help you avoid a real mess with an unfair labor practice charge down the road for allegedly chilling coworkers, for example, communicating on Facebook. So thank you, Dina, that was awesome. So with that, we'll turn to Julia to talk about how to manage pandemic-related mental health issues in the context of the situation we're in. Julia, what should the participants know about this topic?
Thank you, John. And I do love disability law as well, almost as much as I-9s. So again, I will try to keep it short, but the thing about the mental health crisis going on right now, and it truly is a crisis, is it brings into play so many different federal and state requirements that employers have to abide by and that are regularly enforced. But it can be difficult if you are not experienced with it to identify, because these are typically invisible illnesses, correct? So one statistic that I saw recently that I thought was pretty shocking was that in the first half of 2019, approximately 11% of adults reported having some sort of mental health diagnosis, like an anxiety disorder or a depressive disorder. And in the first couple of weeks in 2021, that percentage was up to 41.5%. Okay, and you can, because of, and we'll talk some about this, but because there is some stigma still related to some types of mental illness, you have to believe that that number is actually far greater, because these are the individuals that are actually reporting, who are getting diagnoses, getting help. So for everyone that's out there getting help, there's probably someone who's not. So the pandemic involving mental health is going to be existing far, far long after we have some control over COVID-19. And this is for a lot of different reasons. And I list these, I'm sure you probably know these, but I think it's helpful. If you understand where these issues are coming from, it makes it easier for you to identify them yourself in your employees and in your workplace. So first, financial reasons. That's pretty obvious. A lot of people lost their jobs or their loved ones lost their jobs. So that is a huge stressor. You also have people that didn't lose their job, but are afraid of when the other shoe is going to drop. So they're afraid they might, or their spouse might, or their mother might, or another close family member. Obviously, over 500,000 people have died in this country from COVID-19. A lot of people's parents passed away. And if you've ever done any sociology studying and all of that, having the death of a parent or a close relative like that is among the top 3 most stressful things that can ever happen in your life. So people are going to be dealing with this type of stress as well. And whatever the ramifications from that were, they may have their other parent now residing with them in their house or something like that. And then also, and this is where it really is a catch-22, and I keep saying that to my employers, a lot about the pandemic has been sort of a catch-22, but for individuals that like being alone and maybe were more introverted to begin with, they might be experiencing some real anxiety with going back to the workplace. That social anxiety that maybe they had started to get a hold of is going to be exacerbated now because they haven't had to deal with that situation in so long. But for individuals that were already very social and really enjoyed the camaraderie of the workplace and being there physically, those individuals were more likely to experience severe depression or anxiety as a result of being away from the workplace for so long. So all of these factors are playing in to this particular issue. And the 3 primary laws that I'm going to raise and discuss with you that this is going to invoke are the Americans with Disabilities Act, our paid sick leave law here in Arizona, and the Family and Medical Leave Act. And nothing that I will tell you today about these laws is new. We've always had these requirements, but what the pandemic has done is it has really magnified this problem in the workplace and added a lot of complication to applying these laws. So more than ever now, it is important because these are some complex, difficult to understand laws when you put them into practice. So we want to make sure that you have the tools you need, A, to handle whatever comes your way, and B, to know when it is appropriate for you to reach out, call us, call some other provider for some assistance. So which laws apply to you is going to depend in part on how many employees you have. So for the Family and Medical Leave Act, that's only going to apply to you if you have 50 or more employees. So your larger employers. The Americans with Disabilities Act, the ADA, applies if you have 15 or more. And then paid sick leave here in Arizona, which I have affectionately coined the gift that keeps on giving, applies to everyone. Okay, so I want to start with the Family and Medical Leave Act. And the reason I'm doing that is because employers were amazing. I found them to be amazing during the pandemic at following the ever-changing statutory environment and what types of leaves were available for COVID and what are the reasons and how much do I pay them and what do I do? But because there's been such a focus on specific COVID-related need and leaves, people have tended to forget a little bit about the traditional Family and Medical Leave Act. It didn't go away. Now, if your employees were taking paid family leave or paid leave under the FFCRA, they're still going to have to meet the requirements under FEMLA that they were at work as many days as necessary. I think it's 1,280 hours in the last 12-month period. And they're going to have to have time left. You know, maybe they took 6 weeks off, maybe they're only eligible for 6 weeks. So be on top of your calculations as to how much time people have left. But for FEMLA, this is where employees get to take unpaid leave right now. They're looking at paid leave in the legislature, but unpaid leave to care for their own serious health condition or that of a close family member, typically parents or children. And the children part is very important because children have been disproportionately impacted, including psychologically, by all the changes related to the pandemic. So there are going to be a lot of parents who they're staying home, but this is not caregiver leave. This isn't traditional, you know, they're just out of school right now. It is because they need to monitor their children or get them to treatment. Sadly, things like suicide rates have increased. So these are serious problems that they may be dealing with both with themselves and with their family. So if you suspect, and this is where you need a little nuance, if you suspect that one of your employees may themselves be undergoing treatment for a mental illness or dealing with that with their child, you have a legal obligation to advise them of the availability of FEMLA. So you don't have to make a determination right then as to whether they're eligible. You just need to advise them that FEMLA is out there, give them your standard notice that tells them what those eligibility requirements are. There are different ways to do this, right? You don't want to sit down with Jane and say, well, Jane, everybody thinks you've been acting bizarrely. Do you think maybe you have a mental illness, maybe FEMLA? That's a no. Don't do that. But you want to be looking for some keywords or buzzwords. Employees who are talking about, we've just got a lot of stress going on at home, or I've just been really anxious, or my son is just really having some issues right now. Things like that. You don't have to delve further into that, but you might just say, well, hey, we're here for you. We want you to know that there are benefits available to you. And so here's a packet of information that includes, you know, an accommodation form, a FEMLA notice, those things, if you feel like any of these might be helpful at this time. Another thing with respect to FEMLA is when you are deciding whether or not someone qualifies for FEMLA, virtually any mental health diagnosis is going to qualify, including anxiety and depression. And there are a lot of stereotypes out there, and I will discuss stereotyping a little bit more moving forward, that those are not real or not sufficient illnesses. What I tell my employers is your job, your one and only obligation with respect to FEMLA is to obtain the necessary and appropriate certification from a physician or an appropriate person that this individual qualifies. That, you know, send them your form, this individual qualifies. Once that is done, it is not the responsibility of the employer to make decisions based upon sort of the severity of the disorder or the serious health condition. All that matters for your purposes is that that individual has a serious health condition, they've been certified, and therefore they are entitled to all of the rights that a cancer patient would have, or, you know, someone with a severe disabling condition would have. So try to keep that in mind when you're making your decisions about what to offer and how to treat these individuals. So, and if you truly do suspect, however, that that certification isn't sufficient, maybe you think this was maybe an unlicensed or just a counselor, like a school counselor, something like that, and you don't think it qualifies, you can request and pay for another certification, but be very careful about the manner in which you do that. But if you get a certification from an appropriate person, accept it, go ahead and apply your normal FEMLA processes like you always have in the past. Now, what is going to come up a lot, I think, will be intermittent FEMLA, which is one of, I think, the most difficult things for an employer to actually implement in the workplace. So intermittent FEMLA, this is where someone perhaps just needs to go see their therapist once a week, or they need maybe a reduced schedule temporarily. So while they sort of deal with this, maybe they need to come back to the office gradually, that sort of thing. That is all appropriate. You can do two things, however, to help you manage that situation. The first is you can request that they try to schedule their appointments outside of working hours. You cannot force them. If their therapist is only open during working hours, that they are entitled to go during working hours, even if that means extra time away. But you can ask that they at least try to do that. And you also have the option, but think carefully about it. If this person is in a position that just makes it extremely difficult, maybe they work on a specific team and they're an essential part of that team, you can move them temporarily to a different position. You cannot change their benefits, you cannot change their pay. But if there's a slightly different position that they could do that would make it easier to accommodate their intermittent FEMLA, you are allowed to do that. But I would recommend that you contact us or someone else to discuss whether that's going to be appropriate so that that's not viewed as somehow discriminatory. But if you're really struggling, look into that because that's a way to get some relief. So the next, and the one that we, frankly, we're already seeing some of these claims, and you've probably already seen them or may have seen them in reference to COVID itself, but these are ADA claims, Americans with Disability Act claims. As you all know, if someone can perform the essential functions of their job with or without a reasonable accommodation, you are required to accommodate that individual if they have a disability. Now, we've talked a lot about how to accommodate an individual with COVID, but accommodating someone with a mental health issue is different because stress is one of the largest exacerbators of a mental illness. So if your attempts to discuss these issues with the employee, to implement them, to constantly follow up and make sure they're doing what they're supposed to do, are adding additional stress, that in and of itself can be seen as discriminatory. So it's important under the ADA that you recognize, and you can have this conversation with the employee. Anytime an employee tells you that they have a disability, you are allowed to discuss, and in fact are required to discuss and engage in the interactive process with that individual about how best to accommodate that. So you can discuss with them, okay, what aspects of your job are you having trouble with right now? Typically with anxiety, depression, those sorts of things, the literature is saying it could be trouble focusing, it could be increased social anxiety, sleep disorders. And so if you have someone with a sleep disorder, then you might talk with them. Well, what would be helpful? What would help you? Would you, do you think, be able to come in from 9 to 6? You know, maybe this person shouldn't be coming in at 7:30 right now. You might be able to help them just by accommodating their schedule. Also, you are likely going, if someone has a mental illness, it's not like a physical illness where you can necessarily see various episodes coming. So another accommodation would be sort of increased flexibility with respect to your call-in procedures. Okay, this person's not going to be able to tell you, look, next Friday, I'm going to be having a really bad day. Like, they can't. So you're probably going to have to ease up a little bit on those types of restrictions, at least in the interim, as long as that individual is still performing the essential functions of their job, more or less. So what the CDC and a lot of the federal agencies are providing this type of guidance. The number one tip I hear them giving employers right now is flexibility. Be flexible. And we've all been through so much in the last year that is probably the last thing that you are inclined to do right now because you've been nothing but flexible. And I understand that, but we're sort of approaching the end of the tunnel that is COVID. And the last thing you want is to get hit with one of these pretty substantial lawsuits just as you're sort of starting to get back to normal. And studies have actually shown that individuals who are being treated for anxiety and depression, once they begin treatment, their productivity and their work performance increases exponentially. So it's very likely that if you put in a little bit of time, you give a little bit up front, that individual is going to be a far better performer for you. And you could end up with a net positive, not to mention the goodwill that you are going to garner with this employee and the loyalty that they are likely to show you as a result of you having taken these extra steps. So in addition, something that's coming up a lot is substance abuse. Increased substance abuse has become a problem during the pandemic. And the big thing to remember there, and I'm sure you've probably heard this before, is an individual being in treatment for substance abuse is protected. Okay, that is a protected disability. However, no one is ever protected, whether they have a disability or addicted or not, if they show up to work intoxicated or under the influence of those medications. You can always discipline that individual. That is unacceptable. But keep in mind, if someone is taking time off to go to some sort of substance abuse treatment or something like that, that is probably an accommodation you're going to have to make under the ADA. In addition, a lot of employers are looking right now at whether to do remote or partially remote work or in-person work. And the EEOC did come out with some helpful guidance a while back, actually saying, look, just because your employer allowed you to work remotely when you were forced to during the shutdown, that does not mean they automatically have to provide you with remote work as an accommodation. And that's absolutely true. That said, you are going to need to look long and hard at your individuals who did in fact work remotely and look at their productivity, look at the work product to determine if you get a request from that individual or someone in that same position, whether or not it is truly essential that that person be present in the office 5 days per week. Okay, so that is the type of showing you're going to want to do that one way or the other. If you look at it and you can show, look, she wasn't even able to perform these 3 functions and it costs this much and we're catching up, great. That's great if you get a claim to have that evidence. But there's also the chance that you're going to look through and say, you know, she did just fine. I think it's probably okay if she has Fridays remote or something like that. So you'll want to be considering those types of options. And the last thing is avoid stereotyping with the ADA. Discriminating against people based on stereotypes about their disabilities is discrimination. That is in violation of the law. And in my experience dealing with employers, they often think that individuals with mental illnesses are far more greatly impaired than they actually are because of stereotypes about those mental illnesses. And first, you need to trust the certification that you received. If you have real concerns, you can send a certification for ADA accommodations with that individual to their caretaker, list all of their job duties and ask, can this person do these job duties safely? That helps too if maybe the person's on medication and you have some concerns about this medication. Put that in the certification. They have to be able to, operate heavy equipment or, something along those lines. And then you need to trust that certification when you get it. And I will say, not to make light of it, but one thing I've said to many, many employers is, look, we have a lot of mentally ill folks in the workplace. The last ones we need to worry about are those who are seeking treatment. Okay, so there's a very good chance that these individuals, just like anybody else, are being treated. And like I said, their work product is actually going to improve as a result. And then the last thing, and this is much quicker, is just Arizona paid sick leave. And I mention this because, again, I have seen employers, because you're so overwhelmed with all the different laws you're supposed to be remembering and the leaves and all of that right now, they're forgetting about just good old Arizona paid sick leave. And this law is shaping up to be really difficult for employers, not because it's tough to give people 5 days off, but because of the ramifications if you get one of these claims. These carry $150 a day minimum damages until the date of judgment. So if you get this suit, this person's looking at from the day you terminated me up until trial 2 years from now, you're going to owe me $150 a day if I win. And that makes settlement very difficult. So be careful. Make sure you're documenting when these people get paid sick leave, that you're not getting too overly technical. There's a lot of flexibility with how they can call in, things like that. And if somebody is eligible for paid sick leave, give it to them, because if nothing else, run those 5 days and then get on with the rest of your year so that you won't have to deal with that additional complication. So do not forget your practices with respect to paid sick leave. So the very last thing I'll say, just some recommendations for what you might do. We're focusing on compliance, but most of you I know just want, a lot of supervisors right now, they're saying, are feeling anxious and depressed because they're worried about their employees. They feel responsible for they're worried. And which is great. Those are good employers. Well, what you can do to help, look at your EAP, your Employee Assistance Program. A lot of health insurance plans don't have fantastic behavioral health policies. So look at getting new options that have increased payouts for behavioral health. Make sure that your employees know about your EAP and how to utilize it. And then be open about the fact that people might be experiencing this, because if you have employees experiencing this, you want them to get that help. And because of this unfortunate stigma that some people still kind of hang on to here, some people might not. So, but if you as a leader are open and accepting of whatever they need, it's going to pay dividends for you in the end. So just a few options and opportunities. The last thing, employee recognition. They're scared about their jobs. So now is the time. It might seem silly to you. Put something on their door, give them a shout out in an email, do what you can to make them know that you appreciate them and that they're not going anywhere. All right.
Fantastic, Julia. So much great information in such a short period of time. Wonderful. Thank you. Couple things I'll add to that. The penalties associated with our paid sick time law are remarkable, like Julia has explained them. One thing you need to understand, which makes it even worse if you want to look at it from that perspective, is that, and you may know this, but if you take an adverse action against a worker within 90 days after which they have exercised their rights under our paid sick time law in Arizona, there is a presumption that arises that you have retaliated against that worker for exercising that right. A presumption. Now, you can rebut that presumption if they pursue a claim against you, but the problem is the cards are stacked against you right from the beginning. So someone asks for a couple days off, Arizona paid sick time, they do something wrong, 3, 4, 5 weeks later, you fire them, you demote them. If they get a hold of a lawyer, it's almost inevitable that one of the things you're going to hear is, hey, you took an adverse action against my client within 90 days after the point at which they exercised their right under our paid sick time law. And if you can't rebut that and we pursue you, you're going to be paying $150 a day through the date of trial. It's like Julia said, it truly is the gift that keeps on giving. And on that note, you should keep an eye on this, because I truly believe under the Biden administration, this would not have been true if we had a Republican in the White House for another 4 years. We're going to see on the horizon soon paid sick time at the federal level. I think Congress, once they get past everything that's going on right now, and they have a little bit of time to focus on some collateral issues, I think we're going to see some sort of paid sick time law similar to our Arizona law, but it's going to be federal, and that'll further complicate things. It's 12 o'clock on the nose. We finished the presentation. We don't have any questions right now that I can see. So I will remind you about a couple of things. First, if you need CLE and you're an attorney, just and even if you don't know how or you don't want to chat the information to us, you can email me. I'll take care of you. Just need to know your full name and your accurate email address. Second, if you know somebody who you think would benefit from watching this, please let them know. direct them to the Jennings Strouss website to the events page under webinars, and they'll be able to click on it and watch the whole thing. And then finally, whether this is your first time attending one of these or you're one of our repeat customers, if there are things that you really did or didn't like about this, please let us know. And if there's something that you would like us to address in a future webinar, because we are trying to do these roughly quarterly, maybe 3 times a year, we would like your suggestions, because this is all about taking an hour and just helping you in the most efficient way we think we can. And so if there's something that you would really like us to talk about, let us know, and we will see if we can put it on the agenda for the next one. And with that, thank you for attending. We appreciate you joining us, and have a great day. Thank you, Julia and Dina, for your wonderful presentations. Bye, everybody.